Thank you very much for joining us for the webinar today. I appreciate your patience. Today we have Simon Kent from Kent Employment Law and Derek Sienko from Diversified Rehabilitation Group joining us today to answer some of your questions about return to work and the legal struggles that some of you may have with this. So before we begin, I'd like to have Simon, if you don't mind introducing yourself to everyone who's participating.
Sure. Hi, everyone. My name is Simon Kent, and I'm the founder of Kent Employment Law, which is an employment law firm in Vancouver, Victoria, and Kelowna. And we represent both employers and employees on all issues related to the workplace, including the topic which we'll be discussing today, which is essentially return to work, disability, and workplace issues. So as I say, we've got lawyers in Victoria, Kelowna, and Vancouver, and we deal with both employees and employers. So we've got pretty broad experience on sort of both sides of the ledger dealing with these employment law issues. So I'm happy to be here today and hoping I can attempt to answer some of your questions.
Thank you, Simon. Derek, would you mind introducing yourself?
Good morning. Welcome, everyone. My name is Derek Sienko. I'm the founder and CEO of Diversified Rehabilitation Group. We have offices in Vancouver, Kelowna, Burnaby, and Richmond. We specialize in aspects of return to work and disability services for both employees and employers. We assist both in the return to work journey and assisting them in making it successful. We also help employers and employees in structuring return to work and making sure that they avoid any unnecessary legal hurdles.
Thank you, Derek. This webinar will go until 10:30, but we're going to leave about 15 minutes at the end for you to ask your questions. And if you have questions throughout the webinar, please feel free to type them in the chat. All right, so let's start with our first question. The first question is, do I need a physical demand analysis for all positions? Simon, if you have anything to offer on the first question there, maybe describe what a physical demand analysis is and why it would be needed.
Well, I don't know. Why don't I get Derek to start with that, because I'm not sure what the questionnaire is asking about a physical demand analysis. I take it it's got to do with when a person is attempting to return to work, and perhaps the question is, every time an employee is returning to work, do I need to have some sort of analysis done about their ability to come back and to do their job or their job responsibilities? Is that the way you read it, Derek?
It's close, but from the perspective of what physical demand analysis is physical demand. We do a physical demand analysis, and this is important one for all the critical positions within your company. What that means is positions that are frequently have chance for injury or that are heavily and physically demanding. So those are the positions that you should have physical demand analysis for. The concept of having physical demand analysis for all of the positions, I think it's a little bit overstated. I would only suggest for employers to have physical demand analysis for positions that are critical and as I define them. Probably that's the best way to approach that. And when the physical demand analysis becomes very useful is when you're bringing this employee back to work and you need to have understanding from the doctor's perspective whether the employee would be able to fulfill the duties of the positions that you have. So physical demand analysis offers that step-by-step detailed information for a family practitioner or medical care provider to understand what that job is all about and comment with respect to employees' ability to return to work.
Yes, and I completely agree with that. Again, you're only going to be asking a physician to make comments on a person's ability to physical ability when that is related to their job. So kind of an obvious answer to that one.
We'll go on to the next one. An employee went off work on medical EI. After 3 months, he was cleared to return to work. The employee had 2 unsuccessful returns to work, and last return to work was unsuccessful as well due to employee having a panic attack at work. Now the family physician is recommending an 8-week return to work. What can we do to make this successful for the employee and the employer? So maybe hearing Derek's perspective first from a return to work point of view, and then Simon, if you can offer from the legal point of view.
Sure.
Well, this is, even though the question is fairly specific, it's very vague at the same time. But obviously, if you had an unsuccessful return to work, there are a number of steps most likely that have been missed. Either lack of understanding employees' limitations, cognitive limitations and abilities, having that structure in place. The next thing that comes to mind, was an employee involved in the designing a return to work plan? Was there a preventive plan put in forward, meaning what if unfortunate happen, how we can handle this? One vague component for me here is not unclear medical information from the doctor saying that now employee is fit for return to work, and employee saying, family physician saying that should take place over the 8 weeks. From my perspective, from designing an effective return to work plan, I don't have enough information to make sure that this employee would be okay to return to work, and to have information that will prevent me from any speed bumps. So what I would require, probably, I would take that information to the family physician, trying to really understand this person's cognitive limitations, what he or she can handle, and design a very detailed return to work plan and plan of action in terms of implementation and support, having an employee and his direct supervisor involved in a journey of return to work, to make sure that we have all the support required. And if an individual is participating in some supportive, for example, counseling, which you may or may not know as an employer, but just to make sure that an employee has access to services, some form of support to enhance and ensure successful return to work.
Thank you.
Yeah, I completely agree with that's a great answer, Derek. That's exactly what I would say to my employer clients who are in this situation. There's just not enough information. I mean, you have a GP who's clearing a person to return to work, but then it keeps failing after. So obviously there's a disconnect there, and that maybe the GP is not fully appreciating what's going on at the workplace or what might be triggering this individual. So my advice to the employer would be exactly what Derek said. We need to send a detailed questionnaire that's very specific to this particular employee to the GP to ask more questions, not about what the we don't care about what the underlying medical issue is. That can be a private matter, but what we want to know is what can we do to support this person when they return? Is there sort of a graduated or a gradual return to work scenario that's going to work with them? Just sort of dig a little bit deeper here to find out what is going on and what the employer can do to support the person. And it may be that the person is unable to return, but in the short term, you have to look at short-term disability or long-term disability if that's available with the employer. But it causes great havoc for a person, for an employee to keep coming back to the workplace and then something going wrong, going off again. I know as just an employer myself, it'd be very difficult to manage because there's work that needs to be done in the workplace and you need people there doing it. So if a person's coming back and isn't ready to come back and keeps failing in their return to work, that can divert a lot of resources, internal HR resources, to trying to deal with that issue. And if you're a smaller company, then it just lands in the lap of the person, usually the owner who's operating the company. So in those situations, I always suggest that you get some support through an organization like Diversified or through the assistance of an employment lawyer, and we can help sort of guide the employer through that. including putting together that kind of questionnaire that's not going to be offside and violate any kind of privacy concerns, but it's going to result in everybody being a little bit better, have a better understanding of what's going on for that employee.
We're going to move on to the next question, which is question number 3. Do we need to have a formal return to work program? Simon, what do you think about this?
There's no legal requirement to have a formal return to work program at all. I mean, most times the employee goes off on disability, doctor says they're ready to come back, and they come back at full speed. Derek's got much more experience in this than I do, but generally that's what I see. I don't see that many graduated return to work programs. It's often all or nothing, but that's what Derek specializes in. So what do you have to say about it, Derek?
So from the perspective to help you avoid any unnecessary struggles when it comes to bringing employee back, and then unnecessarily legal issue, I strongly believe that there's a big need for return to work programs. And those return to work programs, many employers are sometimes afraid of bringing that forward because they think there's a significant cost. It doesn't have to be. What the return to work program helps you to accomplish is, first, it sets the standards within your company, as a company, and also for your employees. What happens when an employee goes off work, and makes that return to work a common issue for the entire team, not only for the employer or for an employee. So setting that expectation is very important, and employees knows what to expect when unfortunate happens, and how we're going to be bringing them to return to work. And more informative you are on this area, then less issues you're going to have down the road. And also helps having effective return to work program structured is nicely helps you to be very effective in addressing return to work issues, whether they're work safe related, WCB related, or long-term or STD clients. Regardless of what, when you have nice return to work clearly defined as, and expectations, responsibilities, and also steps that you're going to be following in terms of when unfortunate happens, it only helps you as the employer to have more successful return to works and less struggles down the road.
All right. So moving on to the next question, and this one might be an interesting one for either of you. If your worker's doctor is being uncooperative, how would you manage that? Derek, I'll let you start on this one.
Well, and again, that brings me back to that return to work program, because when your doctor is uncooperative, and if you have clearly stated and defined in your return to work, and your employees are aware that they need to comply with respect to return to work planning, and they need to go and obtain the medical information from doctor and explain the importance why that information is important to have, then that uncooperative doctor, chances for him or her being uncooperative will reduce significantly. But regardless of that, do we get them? Absolutely. So my best approach to you would be really to, if there's an opportunity to schedule a meeting with the doctor and the client, whether it's over the phone or being there in person, usually it's the best plan of action. Having an employee with you in the doctor's office, explaining return to work component and importance of bringing that back is effective. Does it always work? In most cases, does. Do we still have uncooperative doctors? We do. From the legal requirement, what if I don't have that medical information? Simon, do you want to take on that and comment on this?
Sure. Well, Derek, I actually was going to ask you, do you think that often an uncooperative doctor it means an employee who's directing them to be uncooperative, or is telling them, don't give the employer too much information?
Yes, from my experience, absolutely. And this is frequently related to the fact that there's a lack of structure within the employer for an employee to really understand what the return to work and getting back to work it's all about.
Right. Yeah, I've never come across an uncooperative doctor. Often what we deal with are doctors that aren't giving enough information. It's basically a GP writing on a prescription pad, Jerry needs 8 weeks off work for stress. And then, of course, we send the questionnaire and go from there. But I don't recall a situation where a doctor's been uncooperative. I think from a legal perspective, if you as an employer are not getting the information you need, and I'm talking about reasonable information, then I guess I would say that the employer has to seriously consider not allowing the employee back to the workplace. And it's very fact specific, because of course, if you're running an organization that it's a safety sensitive position and you can't get the information you need from the doctor that is usually the GP that is treating your employee, then my advice to my employer client would be, well, I think we have to consider an IME, which is the independent medical examination, where the employer pays for the employee to go and be evaluated by the employer's own doctor, so to speak. And if the employee refuses to do that, then we have to talk about what would come next. And I suspect it could be something like, Jerry, unless you do these reasonable things that we're asking, we can't let you come back to the workplace. So you're basically off on unpaid leave. It gets a little more complicated if there's a short-term disability program, which is being funded by the employer. I've had this before where, you've got an employee who's not cooperating with human resources or with HR, and in a way is like sort of staying off on short-term disability. The employer's funding it, is not happy about that, and I think eventually it can lead to a dismissal for cause in certain circumstances. But that's a real mess, and you're definitely going to want some advice to navigate through that when that starts to happen.
We're going through time fairly well here, so I'm going to skip ahead to one of the longer questions we received. And this is the one that starts by saying, when is it the right time to ask a doctor to complete a medical questionnaire? Just kind of going off the last question that you guys were answering, this question is asking about having a doctor review an employee's job description and then answering more detailed questions. Derek, would you be able to provide some insight on this? When is it appropriate to maybe request this IME that Simon is talking about, or request more information?
So there's when you're in the process of getting employee back to work, there's always I don't think there's a specific time when you can request the medical questionnaire. Anytime it's good, so to say, as long as the employee is medically stable to engage in return to work planning. But when I hear a component that, and frequently this is where employers shoot themselves in the leg, they send a job description to a doctor and ask the doctor to comment on that. I've been in the field of return to work and disability management for years, and I have to tell you, the worst thing that you can get is a job description, because a job description does not fully explain the actual tasks and whether they're physical or cognitive of that position. So here's your excellent opportunity to have physical demand analysis, and then look at this and try to match physical limitations with respect to what is provided to you by a doctor. And this is, you can offer this to a doctor, meaning physical demand analysis, saying, this is what this position is all about. Tell me about Mr. So-and-so physical limitations. And here's a note and warning. Family physician is really not, it's not that he or she is not capable. They don't have time to assess individual physical or cognitive limitations with respect to return to work planning. So you need to look who that the right professional is, whether it's a psychologist or occupational therapist or physical therapist. Those are the people who can assist you effectively to determine what those limitations and abilities are, and then take this information with the care provider if you need for return to work planning.
Let me add to that, and I just go back in time, and I remember a case long ago that I had with an older gentleman who had had a stroke. Obviously, the employer, they sent a questionnaire to his treating physicians to determine whether he was able to come back to work. That questionnaire wasn't sent till, I guess the way it went is that he had a stroke. So obviously a pretty serious stroke. It was a kind of catastrophic event in his life. The employer then is going to give him time to heal. You're not going to run out, obviously, at that point and give a questionnaire. You know, the employer is supportive, checks in periodically, but not to the point of pestering, not to the point of affecting that person's ability to recover. I sometimes see that. When the person who's had this, in this case, a stroke, approaches the employer and says, I'm ready to start talking about returning, that's the time to send the questionnaire. And in this case, because it was a stroke, it was much more than a GP that was taking care of the individual. So the first issue for the employer is, who do I send the questionnaire to? And I completely agree with Derek. When you do determine who you're going to send it to, you don't just give a job description. You give a detailed review of what that person's job entails on a daily basis, including trying to determine, or I guess measure, the person's level of stress that they may or had previously endured in that role. I've seen descriptions of from employers to medical professionals saying things like, Jerry's job was a high stress job, which required him to work long hours and to make safety sensitive decisions on immediately, and then asking whether that professional felt like Jerry could still participate in a job like that. But anyways, back on the stroke story. So when the questionnaire came back, and this sort of raises another point that I'd like to hear Derek's view on, but what I'm seeing is that the professional will say, okay, I've looked at your evaluation, I've looked at your job responsibilities, and you've described the day. I think Jerry seems like he's recovered, but it's a stroke. So we don't really know what's going to happen when he goes back to work. So I think he can go back full time. I'm hopeful, but we won't know till he starts. And in this particular case, the employer said that's not good enough. And I was on for the stroke man, and I said, well, I can't do any better than this because it's the human brain. So he's going to have to come back to work. You're going to have to try it out, and we're going to see. And the response was, unless we have certainty, he can't come back. So do you ever see that, Derek? And how do you recommend that?
I agree. Yeah. The other question that while we were answering was put forward, can I just send functional assessment? Absolutely, you can. If you're a disability management professional, if you're sending full report to a doctor, that's good. If you're an employer who got a full report with the medical information, you shouldn't really have that. You should only have limitations and abilities within that FCE. But yes, you can send FCE to get your answers.
Thank you, Brenda, for sending that question forward. Going on to the next question, this might be a question for Simon, just about the legal restriction that an employer might have if they suspect that an employee may be drinking on the job. What are the necessary precautions to take that the employer can protect themselves, as well as making sure that their employee is safe, and how best to handle this issue without overstepping boundaries?
Mm-hmm. Well, this question just came up recently. We did a seminar dealing with marijuana in the workplace with the July 1st, at least supposedly July 1st introduction of legalized marijuana. We talked about how that might affect the workplace. And really, to me, the legalization of marijuana is very similar to the concerns around that are very similar to the concerns around employees drinking. So we can sort of group the two together here. So whether you are suspecting that your employee has been vaping marijuana at lunchtime or has gone out for 3 beers, it's the same concerns, which are immediately upon any kind of suspicion that this is taking place, you want to pull that person aside. You want to ask them whether it's true. Have you been smoking marijuana? Are you high right now? Are you drunk? If you are seeing any signs of impairment, well, obviously that person needs to be sent home. Again, it depends on the type of job they have. If they're driving a van around all day where you have to pull them off the road, send them home, if they're just lightly intoxicated, you may want to decide that, and they just have a desk job, you may want to tell them to take some time and not work for a few hours and then come back. It's a fact specific thing, but your rights are to inquire and to keep that person out of safety sensitive jobs until such time as you can give yourself comfort or find comfort that they do not have a substance abuse problem. Derek, did you want to add to that?
Yeah, adding to that, I think if you arrive to a conclusion that there's an issue on the table with respect to drinking, once this is already on the table, and you can ask if the employee or support offer employee to go and get some help in that area. If employee comes to you and says, "Listen, I'm not ready," or not, you have no say in making that happen for them. But you have definitely opportunity to say, "Listen, this is not acceptable within my work environment. I cannot have that. If that happens again, I'm here to assist you in the best possible way. But from the safety perspective, I cannot allow that." You can also, if the employee is seeking treatment, and you need to recognize that if the employee is in treatment and still at work, you need to recognize there's going to be a relapse, and you need to be ready for that. So the best plan of action is to put an agreement, and depends on your work environment. If you're in a unionized environment, then I strongly encourage you to have unions involved in this process, because they'll only assist you and helps you to accomplish the ultimate goal more effectively as a team. If you are not working in a unionized environment, the same, follow the procedures, put the effective planning process, have this spell out in writing, get the employee involved in this process, have their medical care provider being part of that process, make sure the employee signs this agreement, make sure that you also have the relapse, so to say, steps in place. What if that happens? Because it's not a question if, the question is when, most likely. So you need to be ready for this, and you need to make sure that employee is provided with either transitional duties or some modified duties, and definitely that the employee is not working in a safety position that would put others and him or herself at dangers.
Derek, when I was answering that question, I was thinking of a scenario where the employee does not want to admit they have a problem. So how do you deal with that?
Well, as a matter of fact, we had a case come to mind where we had an employee who was in that view that he or she doesn't have a problem. So what we requested on behalf of the employer assessment of a psychologist, and the psychologist confirmed that there was a problem. Even though there was a problem, even though we had a confirmation from the medical team as well that there was a problem, the employee was still in denial, saying that there's no issue at all. Mm-hmm. And the employee's explanation was that if I drink on the weekend, which was true, but also it was affecting them at work on Monday. So we brought, that was in a unionized environment, and in this case, actually, family physician was clearing his employee to return to work, but return to work coordinator that served as an independent party said, no, we're not going to be clearing this individual to work because it's unsafe. And as I stated, we had a union involved, and collaboratively, we actually arrived to a conclusion that there was a problem. And with the support of the union and the employer and the care providers who helped this employee to get treatment going, long story short, eventually employee admitted that he had a problem and went to treatment, and after a year of treatment returned to work successfully.
Okay, so would you agree then the steps in that circumstance would be to, if you suspect, to if you suspect that your employee is abusing alcohol, has some alcohol dependency issues, then to go and to talk to them. And if they agree that they do, there's sort of one stream, which you've sort of described. And then if they deny it, then what do you think the employer should be their next step then?
Send for an assessment.
What's it?
Send for an assessment. Yeah, send for an assessment to get a confirmation whether that's the case or not.
From where? From a GP?
No, not G. Well, you can ask for a GP, but you can send to the psychologist and ask. And let's be clear on this. When you're sending this to psychologists, they are able to put the individual through a specific psychometric testing and other tests to determine whether that's the case. If you're just sending this for an interview, which frequently happens with a psychologist, and they arrive to conclusions, then you're not going to get what you're looking for.
One topic I just want to touch on quickly before we open it up to questions from our viewers. Simon, maybe if you can talk a little bit about what an employer can do if they suspect that an employee's claim is not genuine, or if they're suspected of malingering, and what actions they can take if they don't think that their claim is genuine.
Yeah, no, absolutely. I've dealt with these in the past. It sort of tracks what we've already discussed, which would be you've got an employee who goes off on a disability leave. And generally what happens is, you get the GP note that'll say Jerry needs to be off for 2 weeks, and another note comes in after 2 weeks saying that now they have to be off for 4 weeks. And for the employer, it's difficult because you're thinking initially, oh, well, it's only 2 weeks. We can deal with that. I'm sure he'll be back. And then all of a sudden it stretches to 6 weeks. And you're not quite sure what to do. And you think, well, all right, well, I'll hire a temp and I'm sure he'll be back. You know, he's worked here for the last 10 years without a lot of sick time. It should be fine. But then all of a sudden you get another GP note saying he's got to be off for another 8 weeks. And you try, I mean, generally what happens is you try to get in touch with him, but he is non-responsive. And, you know, HR is just not sure what to do. So at that point, you're going to send a questionnaire to his doctor, and you're going to sort of push the issue, right? Sort of push it to conclusion. And so if you get back something that says, actually, Jerry's ready to return to work, but Jerry disagrees and says, actually, my GP doesn't understand me. I'm quite sick. I can't come back. You can always, at that point, have another assessment by somebody else so that you can at least show that you're supportive of Jerry. If he is rejecting what the GP is saying, then you get somebody else. That's, again, maybe an independent medical evaluation. But what I found is that employees who are not being truthful, so just moving off to that part, the malingering part, the sooner you get on that and the sooner you sort of push them for medical information, the sooner that the whole thing sort of collapses. And then, it can end in so many different ways. And the way that I'm thinking of here, that eventually the person resigned because the employer didn't want to pay them a lot of severance to end the relationship. So we just sort of kept pushing the employee for medical information, and eventually the employee just wrote in and said they resign and they're walking away. So staying on it, being forceful, but not to the point of harassment is what an employer should do.
Going off of that question, if a person was underperforming before they went on a leave and now they're back and perhaps still underperforming, what actions can an employer take?
Sure. Yeah. Boy, this happens all the time. So an employer, I've had a number of examples of an employer who was on the verge of dismissing for performance issues, and then they get a medical note. It's often because the employee knows that their job's coming to an end, and so they'll go off on stress leave for whatever reason. And so legally, you have to compartmentalize things. So the first part of it is, this person was underperforming. We've got documentation reporting that. I mean, this is, I guess the question beyond that they're underperforming is whether you're going to try to fire them for cause because of the underperformance and therefore not pay severance, or you're just going to fire them because you want to end the relationship. It's because of performance, but you're not going to claim cause and you're going to pay them severance. So that's the first thing, we have to come to a decision on with the employer. But let's say that the person is going to be dismissed without cause based on performance issues, and just as you're about to do it, the person claims, goes off on a stress leave. And then that goes on for a few months. You do what Derek and I have been talking about, which is you respectfully and positively, supportively determine what's going on with them. You have a robust medical questionnaire answered. There's a graduated return to work potentially, but the person comes back. And at that point, my advice to the employers is, well, I don't think you just turn around and fire them a couple of days later, because you're almost, begging for a human rights claim at that point. So, you bring them back, and you as an employer can decide whether you want to try to work it out with them and try to deal with the performance issues that existed before the stress leave, or now that they are cleared to back to work full time, no accommodation. If you still decide that you want to dismiss them because of performance issues, that's fine. But it's really important to paper the reasons for the dismissal. It's good to see emails back and forth between managers, or that there's been meetings and minutes taken of those meetings about decisions relating to performance, because what's going to happen is, no matter how clean the dismissal is and how much it's related to the lack of performance, that person who's come back from a 6-month stress leave is going to be thinking, rightfully or wrongfully, that the dismissal was because, at least in part, because of their disability, and could then claim a human rights violation as a result. And so you're going to have to go to the Human Rights Tribunal and demonstrate that the decision to dismiss was based solely on performance and completely unrelated to anything to do with the person's medical condition.
All right. Thank you very much for working through those questions with us. We're going to take about the last 15 minutes of the webinar now to answer any questions that viewers may have. So if you want to type it into the chat window, then Derek and Simon will discuss them as they come in. Phoebe sent in a question while we were discussing an impaired employee at work, and the question was, in the example, the employee was drinking only during the weekend, but their work performance was impacted by the after effects of drinking. Could it be argued that being hungover or fatigued can be considered impairment, although the employee may not be under the influence of a substance?
Absolutely. Yeah.
Oh, go ahead, Simon.
Yeah, sorry, absolutely. Yeah, without a question. Someone who's been deprived of sleep, or has it's a medical condition. I mean, being hungover, there's no question it's a medical condition. Person's impaired. Again, I think it depends on what their job is. Obviously, they're on scaffolding or using power tools. That's a big issue. If it's one of my legal assistants being hungover on a Monday morning, and being grumpy while answering the phone, or short with people around the office, then I'm not going to be happy about that, and we're going to sit down and talk about it. But it's not as critical as somebody who's driving a vehicle or in a safety sensitive position. So the answer is yes, that would be impairment in my mind.
Derek, do you have anything?
Yeah, I can only support what Simon shared with us. I 100% agree with that.
Derek wants to go back to one question saying, how long do I need to provide my worker with pre-injury suitable employment after they are injured?
Simon, I would like you to comment on that before I offer my share on this.
Can you say that again, Lauren?
So it was question number 9. How long do I need to provide my worker with pre-injury suitable employment after they are injured?
After they are in, how long do I need to provide my worker with pre-injury suitable employment after they are injured?
I think it's the individual is asking our accommodation. How long do I need to provide accommodation after injury?
Oh, Forever, until it becomes an undue hardship. So if you have somebody who's injured and they need a stand-up desk, you buy them a stand-up desk and they get to stand. I mean, it's a small example, but yeah, I don't think there's any limits on accommodation. A person can be injured and then will need lifelong accommodation, and that's fine as long as it's not considered to be an undue hardship to the employer.
Yeah, I 100% agree with that. My comment on that would be, make sure when you are doing this that every accommodation that you have, or return to work or modified transitional duties, that you have this well documented and supported. Sometimes there might be a performance issue. You need to really distinguish between those two and make sure that you have all the right documentation in place and actions that you took to support the employee or discipline the employee if there was a need for that, and that you follow the process that you have within the company. And also, if you feel there needs to be a consult with either your legal counsel or return to work individuals, I strongly suggest you do that.
And Simon commented on undue hardship. Perhaps if we have time at the end of the webinar, you might be able to elaborate a little bit more on what exactly undue hardship can mean for different employers. I'd like to go to Vanessa's question regarding non-culpable absenteeism. Is there a certain threshold that employees must meet? Can attend a percentage of time to support a no-cause termination? Simon, do you have any opinion on that?
I think I've read it a few times here. I think that the question is asking, so if a person returns to work, has a medical condition that's not their own doing, they return to work, but they can only work, say, 20% of the time that they worked before. Could you dismiss that person without attracting a human rights claim? That's a tough one, if that's the question. Boy, I would say, again, very fact-driven. So in a small organization where that person's position was integral to the running of the business, and now they're only able to work 10 or 20% of what they were doing before, I think an argument can be made that our small business can't accommodate that change, and it's an undue hardship, or the hardship is so extreme that we shouldn't be made under human rights legislation to accommodate that person. And other circumstances, like where maybe the position is, let's say somebody working in the warehouse, stocking a warehouse, and it's Jerry again. He's a forklift operator. He used to be able to work 40 hours a week. Now he can only work 10, and it looks like he can only work 10 for the next year. Could you dismiss him because of that? I'd probably say no to the employer in that case. I'd say, I think you have to make efforts to show that you've attempted at least to hire somebody who's willing to work as a forklift operator for 30 hours a week to sort of backfill what Jerry can't do. So it's all to do with this issue of, how difficult is it how much of a hardship is it going to be to the employer to accommodate the needs of the disabled employee. And if it's too much, if there's sort of a line there, then you're going to be able to end the relationship through no fault of anybody's. It's like frustration and saying, you've been so injured and I'd love to have you back, and we're willing to do whatever we can, but what your GP or your professionals are saying you need to come back to the workplace, we just can't do it. It's going to cost $500,000 to outfit the building with the types of devices and medical support that you need. And, we just don't have that money. We're too small. We're sorry. And then the relationship is frustrated because of an intervening outside event, that being the accident or the medical whatever led to the medical condition.
So looking at the next question that was posted, kind of going off of the previous question, so if the employer is not able to make appropriate accommodations from their previous job, are they required to create a new position that employee could potentially do?
Again, fact-driven. So if it's a large organization and it's not going to be a hardship to, and employers have different definitions of hardship. So you have to look at it from sort of an objective third party's view, like someone sitting as a hearing officer at the Human Rights Tribunal, looking at your business. Jerry was injured, can't come back to his previous job, but you've got 300 positions. And it seems to me, from the evidence presented to me here at the tribunal, that you could have slotted Jerry in somewhere else because he has, these skills which are transferable to other positions. So I would say that, in certain circumstances, yes, the employer would have a responsibility to find a similar job that Jerry could work in. But if you're a small employer, and it's going to be too much of a hardship, you don't have to, if there's only 4 of you sitting in a room working on a startup company, well, there's probably not going to be another position for Jerry. So then it's understandable that you can't do that. So again, very fact-driven. It's a fact-driven answer.
A lot of variables at play with that question.
Correct.
We have about 8 minutes left, so if you have any more questions, feel free to put them in the chat, or if you think of them after the webinar, you can email them to us, the same email that you were invited to this webinar. And feel free to send your questions in whenever you think of them, and we may be able to address them in the next webinar or in a blog post or with an email back to you. Derek would like to discuss one more question. So can I ask for a diagnosis from my doctor or a medications list?
Simon, would you like to comment on that?
Can I ask for a diagnosis or medications list from the doctor? I would say generally no. So you're generally, when you're asking a doctor for information, you're not asking for a diagnosis. That's most times going too far. What you're concerned about as an employer is when is Jerry going to be able to come back to work? And once you tell me that date, will he be able to come back full-time or part-time? Are you suggesting a graduated return to work? And if he is coming back, what kind of accommodations does he need? As an employer, it's very rare that you need to know what the underlying problem is. You need to know the answers to those questions I just posed, but not ultimately what is wrong. Most times the employer does know, but just from a legal perspective, you don't need to know the diagnosis, and you also don't need to know what the medications list is, because I think the question should be that you ask is, will Jerry be on any medications that might affect his ability to perform his job, and this is what his job is. Again, if you start getting into what medications he's on, then that might open the door to what is the diagnosis. So there's certain information that the employer does need, but you got to be careful not to go too far.
So I really agree with Simon that from the disability management perspective, as an employer, I 100% agree with what Simon said. But if you are an employer who has third party who's managing your disability claims, the third party, and obviously I'm referring to the third party that's qualified to offer those services, they can ask for this information because that information will be going to the employer, will stay with that third party return to work company that is offering those services, and they will work with the client, with your employee and the doctor, and you helping employee to get back to work without disclosing the diagnosis or list of meds. Now, with that in mind, if you are in a unionized environment, you really need to look and see what your collective agreement is stating on that, because the collective agreement might be precluding this information from taking place, or there might be a perception from the union that this info, because the company was hired by the employer, the information is being fed to the employer. So you need to clarify those boundaries, and usually this is clarified at the table during formation of return to work or disability management program, so that foundation and details are clearly explained and detailed so people know what to expect.
Before we end, I just want to address a couple more questions that were sent in. So one from Nelson asked if we could clarify slide 15. If you have an employee that's been off on long-term leave on a couple of occasions and you're suspecting them of malingering, is it termination of benefits or of employment? He's interested to hear more about grounds for terminating employment while on leave. He heard something about frustration of contracts. Simon, do you have anything to add to this?
Yeah, got lots to say on those two, but I'll keep it short. So the number one question, I think, or the hardest question for an employment lawyer is, can I dismiss a person while they're off on medical leave? And if you ever want to see a lawyer shake with fear, you ask that question. So I think the short answer is it would be a very rare day that I would recommend to an employer that they dismiss while on leave. You're almost guaranteed a human rights claim at that point. So you have to, and it's such a hard thing. I mean, I'm an employer myself. I really feel for employers in this circumstance. A lot of times employers feeling the process is very unfair to them, very focused on the employee only and not about how, the efficient operation or running of the business. But the reality is that when a person goes off on disability, do not think about dismissing them. And if you do have some reason for wanting to do that, then you better get some very, very good legal advice in relation to it. And so let's just talk about frustration. Well, maybe I'll finish by saying, in the case of a malingerer, then that's a bit different, right? But even that, you got to be so careful because, you're going to have ironclad proof that this employee is committing fraud, that they are not sick. And the things I've seen are just crazy. The employers following employees around, trying to video them while they're off on disability, trying to prove that they're okay. Recorded meetings, audio recordings, telephone calls to them, harassing calls every day. If you're sick, why did Joni see you in the mall? Like, it gets all crazy. So you really need some guidance in those circumstances. If you feel that somebody is malingering and not telling you the truth, there's a process to follow, and get some guidance from a legal professional. On the issue of frustration, so frustration, there's different ways to end an employment relationship. A person could resign. You could fire them and pay them severance. You can fire them and not pay them severance, so that's firing for cause. Or the relationship could be frustrated, meaning that you entered into a contract with somebody, but an intervening outside event has occurred, which means that contract can't be performed anymore. So, for instance, if the employee was to die, well, he certainly would have frustrated the contract there. If the employee becomes so sick and the prognosis is that they're never going to return, that's frustration. And you don't have to pay severance in that circumstance, because again, it's been this intervening third or outside event that's occurred, which has rendered the contract impossible to perform. Now, employers will often say, well, Simon, when can I do that? When can I do that frustration thing and claim frustration? Unless it's a catastrophic injury or medical problem, which it's obvious that Jerry's never coming back, then you really shouldn't claim frustration till about the 2-year mark. And I've had cases like this where a person's been off for 2 years, doctor keeps saying, not sure what the prognosis is, but eventually after 2 years, you are gonna, in most situations, have the right to say, frustration, our relationship's over, no severance. But again, I really implore you to get legal advice around those decisions.
And if we have time, we understand if you have other things to attend to in your day. There's just one last question about what if it is determined that the employee should be sent for an IME? So Simon, you talked about an IME earlier. How is that handled? Does it yield the medical history, diagnosis, treatment, and is that sent to the employer or is that sent to the employee?
Yeah, I mean, this is done very often by ICBC in personal injury cases where ICBC, doesn't want to listen or entirely to what the person's treating physician is saying about them. They want a neutral third party to do an analysis or review of that person's medical conditions. And it just depends on what medical condition that person has, but the IME physician would be doing a full full breakdown of what that person's medical condition is, what they think the prognosis is, what are their physical limitations. You know, they could build a graduated return to work program. You may want to include an occupational therapist. But when you start talking about IMEs, again, that's something that Derek and his organization could set up, because he'll know doctors in town who specialize in different medical areas which are related to what's wrong with that particular employee.
Well, thanks, Simon. I really think when the medical information comes with to the employer, yes, there is a risk that that might be happening. My best suggestion to you as a employer is to hire a third party, to ask them to facilitate this and offer you only with limitations and abilities, because that puts you in a good standing with all the predicaments that you might be facing from the legal side. And it also offers you a clear understanding when an employee is at, and also helps you, if you need more clarification, to go to a care provider to access this in a way that will again be very effective for you to understand what this employee's limitations and abilities are without jeopardizing confidentiality. So what I'm trying to say is, if you hire a third party to help you with that journey, most likely medical care providers would be more open to discuss this with them, because they know they are assisting in the return to work process, but that they are not an employer where you have access to all the medical information.
Right, and I'll just add in closing there that one of the issues I see is for smaller employers, they just don't want to pay or have the money to pay for an IME. So it's often something that is done by larger organizations. And I think also you have to pick and choose when you do it, because in a way it could be seen as the employee as you not trusting them or their medical provider. So if it's a policy that you have as a large organization, you know, when a person's been off for more than 60 days, that they go to a particular doctor that works with the company, that's one thing. But you know, it's just something that is great in practice, but is not done that often in my experience. Now, Derek deals with this every single day. In my experience, most times the employer is relying on the medical professionals that the employee has. And when I suggest an IME, they kind of go, oh, that sounds too expensive, and they don't do it.
And I do agree with you, Simon. The IME is the last thing that I would recommend for employers to have. There are other ways how you can go and access the information without spending all of that money. And there's also a relationship issue that it's at risk as well.
Great.
All right. Well, I'd like to say thank you to Simon Kent from Kent Employment Law for joining us, and to Derek Sienko from Diversified Rehabilitation Group for joining us, and for all of you for joining us for the webinar today. I encourage you to go and look at the blog on Kent Employment Law's website, as well as DRG's website. A lot of the topics that we discussed here today can be discussed in more detail there, and to sign up for our webinar, which will be the last Friday of February. Thank you for joining us. And if you have any more questions, please email them to the email address I listed in the chat there. The recording of this webinar will also be made available to everyone who participated. Thank you and have a great day.
Great. Thanks, everybody.
Thank you. Bye. Have a good day.